That we have two matters before the court today in the Worthington case. A motion for preliminary injunction and a motion to dismiss. The court would like to hear the motion for preliminary injunction first, and I'd like the parties, if possible, could you both approach and use the microphones? And if you could please state your names for the record.
Your Honor, I'm John Worthington, the plaintiff in this action.
Mark Hawkins, Assistant Attorney General, representing the defendants.
And I, to the extent I can, I'm going to try to turn up the volume because I want to make sure everybody can hear these proceedings.
Thank you, Your Honor.
And as I turned up the volume, I hope, can we test again to see if people can hear?
Testing, this is Mark Hawkins.
John Worthington.
Okay, we'll proceed then. I think that's a little bit better and everyone can hear. This is a motion for preliminary injunction. Mr. Worthington, it's your motion. Again, I apologize that the court schedule is so booked that I'm going to have to limit your time. But if you can limit it to 10 minutes per side for each of the two motions, I'd appreciate it. You may proceed.
Your Honor, the state didn't respond to the preliminary injunction other than to make a jurisdictional argument. So I can only be brief because the state hasn't provided any briefing on whether or not the Tyler Pipe industry standard is met or not. Tyler Pipe is still the industry standard, and as we stand before you...
I'm sorry for the interruption right at the beginning, Mr. Worthington, but it seems to me that, based upon your limited comments already, that it may be appropriate to combine the two arguments. What do you think about that? I'm not prepared to deal with the other argument right now. Very well.
I'm just on, as far as the injunction goes, the regulation that they developed with these unlicensed people and non-applicants was not something they could do. It's an illegal act. They have requirements under the law that they were tasked to adopt. They didn't follow those requirements. So I believe, according to the Tyler Pipe standard for issuing a preliminary injunction, I should be allowed that injunction to stop what I feel is an illegal hemp seed purchase with the aid of the state for persons that weren't in compliance with the statute. And I'll stop there and let Mr. Hawkins have a crack at it.
So I have some questions for you, if you don't mind. So the Tyler Pipe standard addresses certain elements, including the merits. Now, the court isn't addressing the merits at preliminary injunction, except to the extent that Tyler Pipe requires that.
It does, Your Honor. It definitely does. And I'm saying, if now you're forcing me to address the other argument, which is fine. The state does not have a final agency decision. The Supreme Court has ruled on every issue before the court today, and they've set a standard for what the agency has to do to qualify for a final agency decision. They need an agency denial letter to me. And in this case, the act I'm complaining of happened on April 5th, and so the denial letter would have had to been addressed to me sometime in mid-March, to give me time to object to the act on April 5th. They don't have a letter to me. They were told that it was argued by me that they had to provide that to the courts so they could meet the standard by the Supreme Court to decide that issue. They have not provided you with a denial letter. The Supreme Court also mentions what they call statutory notice. And the statutory notice is found in the APA, and it's not a rule. What they did on April 5th is not a rule. If it was a rule, it would be required to be published with the Washington State Code Revisor's Office, and it wasn't. If it was a policy interpretation it still is required to be published with the Washington State Code Revisor's Office. And if it's just a advisory interpretation, then it still has to be published with the Code Revisor's Office. There isn't a case that allows an agency to show up in court and allege a final agency action without satisfying these three facets. The Supreme Court has already ruled on multiple cases that this is what's required. That way you can see and judge whether or not the agency meets the standard, the other standards set by the Supreme Court, whether or not it has the finality to it. And I've argued this. The state hasn't argued that. They've created like a CR8 whole and pleading standard that they're trying to cover the entirety of my argument, and that only addresses whether or not Feebles acted independently of the state. And they can cure that problem by just providing an email or some type of instruction to the state. Because the state stands here with no evidence before the court, as is required by the Supreme Court. If I was George Carl, I'd be sitting on the scores table, I'd be up by 20. If I was the Sonics. They don't have the evidence that they need to prove that there was an agency action. They're not there yet. And in fact, what they do have are two competing policies. One policy says, and this is the only one they publish in front of the agency, one policy says, don't do anything until you have a license. That's actually the statutory correct policy. Don't do anything until we tell you to do something. That is still not published in the Code Revisor's Office to make it what the Supreme Court would accept as a statutory notice requirement. They didn't meet that. And when there's competing, the Supreme Court has also ruled a person doesn't have to exhaust the administrative remedy if the agency is stuck on two competing policies. And here, that's what they have. They have a policy to let these guys get it to one group who's unlicensed and non-applicants. There's no definition for that in the statute. And so the only thing they could have done at that point is argue that one or the other is final. But they can't do that. And when a person or somebody challenging an agency decision comes up against a scenario like that, because they have two competing policies, I'm not required to exhaust my administrative remedies.
Mr. Worthington, it appeared to me in the briefing that the state agreed that you're not required to exhaust. Did you read that in their briefing? Okay,
I did.
so we're all on the same page with regard to that.
But they want me to do it in RCW 3405 Section 4. But without it being in the Code Revisor's Office, it's just, even if it was, it's advisory. Even if it was, it's against the statute. That makes it a nullity. And they didn't address that argument. That's also in the briefing. I'm saying that they didn't have authority, and therefore whatever final agency decision they have or think they have, it's a nullity because the statute only addresses licensed persons and applicants. There's nothing there for them to deal with unlicensed persons. And they could have provided a letter saying that, well, we advised Emily Feebles to do this. We said, you know what, you're not going to make it. Go ahead and work with this select group people first and get it done. And they don't have that. Very well may be that Emily Feebles has a letter like this from Steve Fuller, and I've asked for that in discovery, but as they come before the court right now, they don't have a final agency action. They can't prevail on the merits because they don't have that. And they haven't met the statutory requirement to serve me proper notice or the public proper notice. It's settled.
Mr. Worthington, did you read in the state's briefing where it indicated that other than a final agency decision, there are other ways that matters are reviewed through the APA?
I did.
Okay,
and
what's your response to that?
And I showed the case law, which is cases similar to mine, where I still have to provide a final order by the agency to proceed under the APA. Anybody who's tried that, the agency argues that it's untimely and that they don't proceed on it because they don't have, and then if the court rules that it's a rule decision, and that's one thing, but if the court rules that it's an advisory opinion or a policy opinion, those are just that. They're not even binding. The case law on that shows that they're not I can't proceed, an appeal can't be heard until they provide the agency, the final agency ruling. So this matter can't, I could get sanctioned for bringing an action under the APA without a final agency decision and without any type of statutory notice or without a final agency denial letter. I have nothing to proceed with. Now, if you rule that somehow they do, well, I suppose they're putting you in the position of having to make those decisions because they didn't argue them. And now you have to represent the notion that they complied with the statutory notice to make it an APA action. They still have to make it an APA action.
So, Mr. Worthington, I'm not sure I agree with you, but that aside, many APA actions that are meritorious argue exactly what you're arguing, which is that the agency didn't follow its own procedures. Isn't that exactly why a party is required to go through the APA process when they allege, as you are alleging, that the agency didn't follow its rules?
That would be a rules challenge at that point, and the Supreme Court is clear again that an advisory opinion is not binding. So therefore, I can't even go into the APA review to challenge it because the reasons I just mentioned, it's not there yet. They haven't notified me. I have nothing to take into an APA review other than an action that's off the books and not in accordance with the statute. So let me cite the case. Let me cite the case that's similar to mine, and I've already argued it in a brief. The case that's similar to mine is WCH Inc. versus City of Linwood, and it's what constitutes an agency issued letter. At least in that case, they allowed someone to proceed under the Declaratory and Injunctive Relief Act, just like I'm trying to do right here, because the agency didn't have, they had a final appealable order, but it didn't fix a legal relationship, and it didn't clearly, understandably, as a final determination of rights. If you have a doubt to whether they provided me with that, you're supposed to decide this matter in favor of the plaintiff. I have no recourse under the APA right now. I'm going to do an APA action, but this argument that they're making is done so to avoid a legal remedy right now so they can finish consummating a deal off the books. It'll push it down the road another week. They've already ordered these folks seed, so this is their only hope. They'll probably get sued by those people if they don't go ahead and follow through with that transaction off the books. So they have to make it seem like, well, he can't do this now without an agency action, without adhering to the Supreme Court's requirements, so that they can finish this deal, and then later on, when I come back to them under the APA action, which I'm going to do, but I need more information first, and that would include something from the agency that says we authorize this, something to differentiate whether or not Bevels is acting on her own or whether she's acting at the control of the agency that told her to do these things. I can't proceed under the APA and challenge the rule, and under the Supreme Court's rulings, I can't challenge a nullity because it's not in accordance with the statute. The state didn't argue about that. And I can't challenge an advisory opinion because it's not binding. And I can't go, the Supreme Court's already ruled, I can't proceed in a rules review challenge, which you're right, I will make and I'm going to make. But as far as the agency action under RCW 3405-370 Section 4, which is other agency action, which is what they're saying, I can't challenge an advisory opinion under that because it's not binding and it hasn't been published yet at the Code Revisor's office. They're jumping the gun because they need to jump the gun because they're caught red-handed in this deal, and they need you to dismiss this case so they can proceed with this deal that I'm trying to unwind because it doesn't adhere to the statutes.
Mr. Worthington, so you've utilized more than 10 minutes. It appears that these arguments are combined at this point. which is fine with me. It doesn't matter. I want to just give you your full time. Would you like to reserve the rest of your time after I hear from
Yes,
Mr.
Your Honor.
Hawkins? Very well.
Your Honor, it's difficult to segregate the two motions for me because of the argument that Mr. Worthington has just made. So I'm going to try to integrate my argument to respond to the motion for the TRO and refer to my motion to dismiss for lack of subject matter jurisdiction, if that's acceptable.
Well, before you proceed, I just want to ask, did you not respond to the motion?
I did not respond to the motion, Your Honor.
And can you explain why?
Yes, Your Honor, because in the motion to dismiss, we referenced that the kinds of relief that Mr. Worthington was seeking were not allowed under the law. There's no law that allows a party to bring an action against a state agency under the Consumer Protection Act. There's no way this court has general jurisdiction to even hear this motion because it's the only way this court can hear challenges to agency action, the kinds of agency actions that are alleged on the face of his amended complaint.
I understand your argument because I read your briefing, but I don't understand why the state would not respond to the motion.
Your Honor, because the motion, the court should not have jurisdiction to hear the motion. That's why I was expecting that the court would hear the motion to dismiss first. Your Honor, the law is so clear that the kinds of matters that are alleged in the amended complaint, which is what any motion has to depend on, what is in the amended complaint, depends on this court having subject matter jurisdiction as a trial court to grant the relief requested. And in the absence of the court having that subject matter jurisdiction, the court should not hear this motion and should dismiss the amended complaint. It's a threshold matter, Your Honor.
I don't disagree. I still can't get past why the state would not respond to the motion, in addition to filing whatever motion the state wants to file.
So am I precluded from arguing in responding to the motion at this point? Is that what you're telling me, Your Honor?
I'm not telling you that.
Okay.
If I would tell you that, I would be very clear in telling you that.
So Your Honor, the motion is seeking relief that would be adverse on its face to at least 7 or 8 individuals in a corporate entity. So there's a failure to join necessary and indispensable parties. It's just on the face of it, there's a defect. On the face of it, there's no authority for a court to order relief against a state agency under the Consumer Protection Act, and I think the court is aware of that. We briefed that, and he has not responded to any of that in our motion to dismiss. So he is seeking a declaratory judgment that he's entitled to these remedies, where all of the declaratory judgment relief that he can seek is only available under RCW 724-146, exclusively if he perfects the petition for judicial review in this court. So the point is that he's brought a motion that rests on this court having subject matter jurisdiction, which we've asserted that the law is clear and the legislature has made clear under the APA, that's his exclusive path to this court. So there shouldn't be any issue as to whether he's entitled to any relief under a motion that has to depend on the amended complaint's assertion on the face of the facts alleged that this court has subject matter jurisdiction.
Mr. Hawkins, I have a couple of questions.
Yes, Your Honor.
The first is, do you have a response to Mr. Worthington's claim that WCH case applies to this particular case?
Yes, Your Honor. That case does not involve a state agency. There's no case law that creates an exception for a state agency. That is a case involving a local jurisdiction.
And my next question relates to the use of your term perfect, which is what you use in your brief. putting that in layman's terms, are you essentially saying that Mr. Worthington need not have done anything other than frame his complaint to this court in terms of an APA cause of action?
No, Your Honor. The petition for judicial review, there are a number of elements that he'd have to meet. He'd have to meet a standing requirement, a timing requirement. Today he's stated before you that the event that he has issue with occurred on April 5th. So he would have to timely file a petition for judicial review of other agency action within the time set under the APA to do that. Assuming he did all of those things, then what happens is the next step is for the agency to file its record with the court within 30 days. He can then he can also seek temporary relief under the APA. There's all of the issues that he's complaining of potentially, hypothetically, relief could be granted under a properly filed APA petition for judicial review, where this court is only functioning in an appellate capacity based on the record. So there has to be a record. As you know, the court is in an appellate role. So in the absence of him doing that, and I think, let me just back up a minute. One of the things that he's been arguing, and I think the court was aware of this, is that there's somehow, which he hasn't provided authority for, an exception from him having to file a petition for judicial review of other agency action because he's alleged that this action wasn't a final order or something like that. The court is aware that the APA, our CW 3405, 570 has several different paths for challenges to agency action. One is for challenges to rules. One of them is challenges for final orders, typically that have arrived out of an administrative appeal, so a party can petition for that. And then, unless the court wants to, unless Mr. Worthington would ask the court to ignore 3405, 570, paren 4. And the legislature's made it really clear. Anything that's agency action that you're challenging is other agency action. That's your path. If you believe, as Mr. Worthington apparently believes, that he has been harmed somehow by the things alleged in his amended complaint, that was his avenue to file. That's what the legislature said he had to do. And that's why this court should not even consider his motion for temporary relief and should address first our motion to dismiss. The court.
Further?
No, Your Honor.
Mr. Worthington.
What you just described was exactly why there are statutory requirements. They're trying to push me out of this complaint so that I will have to retroactively argue, claim he's already admitted that I've lost my opportunity to do so simply because the agency didn't file one of these, which gave me the statutory required notice.
So I can't see what you're holding up. Is it a document in the record?
This is something the Department of Revenue says. It says adoption of interpretive statement. If it was a policy statement, it would be something like this. It would have a Washington State Department of Agriculture heading on it, and it would have been filed with the Code Revisor's Office, so I wouldn't be foreclosed conveniently on this incident that happened that they didn't provide me notice of. So their position is clear here, clear as a bell. They want to stop this case, so I'll be required to go back into the APA, which he just argued my remedies are foreclosed because I didn't respond in the right amount of time. So because they didn't provide this notice to the public and me in the form of a denial letter, I have no other, and now let's go to the exhaustion of administrative remedies. Fairness. That's one of the reasons why a judge, it's not fair for them not to provide statutory notice and the court foreclose this case and then send me back into the APA where counsel has just admitted to you that the time has expired for challenging that decision because they didn't post it for everybody to see. They didn't send me a denial letter. And yes, the legislature has spoken on that issue, and that is why there's a statutory requirement. Because if I don't get it, well, guess what? I'm foreclosed on the APA process. So there is no other remedy for me, and that's another condition of exhausting the administrative remedies that I briefed upon. No wonder they didn't brief upon any of the exhaustion of administrative remedies, because they have no agency order. The CPA applies to Feebles, however you say her name, until the state takes responsibility for actions. And that has to come from one of these. They have to show that this is what Feebles is doing. They have to give everybody notice this is what Feebles is doing. And they didn't do that. They have nothing to the code revisor's office. On their website, they say, don't anybody order seeds. Just wait till we tell you what to do. And then the other policy, the secret one, which doesn't comply with the statute, is here. We'll organize these people and we'll allow them to buy seeds without a license. The form says they have to have the license. The form also says they have to have a certificate to one of these. And so the state's getting away with not providing any evidence to this court that they followed the statute. If it were me, I'd have to provide a signed signature here of the people that were involved in the importation process, and they don't have it because they weren't licensed. This goes to a licensed person. It doesn't go to an unlicensed person. It doesn't go to an applicant. So they can't show that they complied with the state requirement. And that's the only, because the agency draws its authority from the statute, they can only do what the statute says. Did they do what the statute says? No, they didn't do what the statute says. Did they do what the Supreme Court said and provide notice? No, they did not. Now I'm foreclosed on an APA challenge because time has passed for me, because I wasn't on the ball and I didn't have a crystal ball to find out what they did in April, which would have been March before it started. I have no way to go back now. So you heard it from them. I'm foreclosed. And because I'm foreclosed, I have no other avenues. I meet the exemption requirement to exhaust administrative remedies. Thank you, Your Honor.
Thank you.
Your Honor, the legislature's, for whatever reason, whatever policy reasons, has been very clear that the path to take on an agency action for the kinds of complaints that Mr. Worthington has raised is through the appellate process of filing a petition for judicial review. When that happens, he would be entitled to make the kinds of allegations he's making in his argument today and in his briefing. He could argue that what was happening was unconstitutional, which is one of the things he raised in his amended complaint. He could argue it's outside the statutory authority of the agency. He could argue that it was arbitrary and capricious. He could argue that the person was taken by persons not authorized, which is what he's saying about the program manager. He can obtain the kinds of relief that he's seeking in his motion. He can obtain temporary relief, stays, he can have things remanded, etc. That's what the legislature said a person has to do.
Mr. Calkins, would you agree with Mr. Worthington's analysis of indicating that what you're pointing him towards is actually a dead-end road because he can't obtain any of that relief?
Your Honor, I think it's premature to come to that conclusion.
But what can you represent to the court? Can you tell this court that if the court says, Mr. Worthington, you have to go back to the agency and proceed through the APA, that he actually has a viable path?
Your Honor, he would have a viable path if the other agency action that he is asserting was illegal, unconstitutional, arbitrary and capricious, or was taken by a person without authority, occurred at a point in time where he can timely, where he A, meets the standing requirements under the APA, and B, can timely file that petition. If he can do those things, he can properly bring to this court in its appellate capacity the option, the ability to rule on his complaint.
Can
But
you not answer my question today?
well, I've never heard a date specific for what Mr. Worthington is saying. Your Honor, one of the reason I raised the issue of standing, that's also a threshold issue. The case law makes it clear that failing to timely file a petition for judicial review the court lacks subject matter jurisdiction. But for challenges to other agency action, there's more room for a person to argue as to when they would have had notice, because other agency action isn't an action that the person has necessarily gotten notice of, like adoption of a rule or a final order. That's why that separate form of requesting the court's review of agency action, the legislature included that. There are lots of agency actions that aren't rulemaking, that aren't adjudicative proceedings, etc. So it appears that the kinds of complaints he has, however he wants to characterize them, fall squarely within the broad definition of agency action under the APA, and that falls squarely within his right to file a petition for judicial review of other agency action. And under the APA's statement that the exclusive means of coming to the court, unless he can show an exception, which he hasn't done, he has no case law. All of the cases he cited have nothing to do with supporting an exception for challenges to state agency action. His only remedy, assuming the court is willing to grant our motion to dismiss, would be to determine whether he can file a petition for judicial review of other agency action. And he would have to meet the standing requirements and the timing to file.
Thank you. Anything else, Mr. Worthington?
If you're going to rule that my motion is dismissed because the agency is not subject to the CPA, they haven't met their burden of proof to show that Febbles acted under the direction of the agency. I've already made my arguments. His assertion that you don't have case law in front of you for exemptions, exceptions, is incorrect. They ignored that case law argument, and he still hasn't responded to it orally here. The Supreme Court has ruled on that issue, and they have provided nothing in the form of briefing to dispute it. They have no final agency action. You can see where they're steering this thing. They got an illegal deal. They need to buy some time until it can go through, so those people probably don't sue them. They want to push me over, and I've up the state before. They will make an argument over here and change that argument over here, even though they're judicially stopped from doing so. If you allow them to do this, at least do a finding of facts and conclusions at law so that I can use that either to pigeon-toe, to show that this is what they argued over here, and I'm ruling that this is what it is today. He's not foreclosed, but they're not saying that. They're saying I have to meet the threshold requirements. So they're still trying to get you to dismiss this motion so they can get me over the APA, where this mysterious agency action that took place, I don't know when, I'm not going to be able, they're going to argue exactly what I'm afraid they're going to argue. That's what they do. They're going to win here and go over here. When I do get to the APA, they're going to change their position, and then I won't be able to argue any of this. Meanwhile, the secret lucky skunks are going to get their seed that the state helped them order without a license. Thank you, Your Honor.
Thank you. The court is prepared to issue rulings at this time. I have some comments for both parties, though, before I do. The court is in a difficult position here because the parties have conducted briefing in this case that doesn't respond to each other's briefing. And that makes it difficult because the state chose not to file a response directly to the motion for preliminary injunction, but rather rely on its briefing regarding its jurisdictional arguments. In addition, the plaintiff here has not addressed all of the arguments of the state. And perhaps that's because the motion to dismiss, which is a dispositive motion, typically would be filed and considered under the court's dispositive motion session with a longer briefing schedule, 28 days notice, and that sort of thing. That didn't happen here because the state wanted these arguments at the same time because they overlapped, which I understand. And at the risk of sounding overly procedural, these procedures are necessary for the court. They're necessary because these procedures here in this court are important to the opposing side. And while each of the parties here make arguments that each of the parties want to benefit from the procedures and the statutes and the regulations, they don't want to be held to them. And each of the parties has to be held to the procedures of this court. The court at this time is denying the motion for preliminary injunction. The court is deciding that based upon the Tyler Pipe standard. This is not a final decision by any means as to the outcome of this case. But based upon the case law applicable to this court, the court finds that the plaintiff has not met its burden at preliminary injunction to impose an injunction. The court's denial of that request is without prejudice. In other words, the plaintiff could bring another motion at any time for the same relief. But at this stage, the court is denying that motion for preliminary injunction based upon its reading of the authorities. With regard to the motion to dismiss, the court is not dismissing the case today. The reason the court is not addressing the motion to dismiss is the court believes that the state has put on sufficient authorities at this stage, and again, this isn't even summary judgment, so the court's not reviewing evidence, but the court is determining that there are enough questions about the petitioner's ability to proceed and questions regarding jurisdiction that the plaintiff has not met its burden at the preliminary injunction stage. However, the court believes that even though its rules are somewhat unclear on this, which again makes me understand why the parties have done what they've done, a motion to dismiss should be noted on the dispositive motion docket and allow the parties to brief consistent with a 28-day briefing schedule for the court's consideration. And so that motion is denied without prejudice. I understand the state's argument that it believes the court should address this matter as a threshold issue as soon as it possibly can. But again, the parties don't dictate the needs of the court in addressing these motions in a way that makes sense to the court. And so that is the ruling of the court today. The motion to dismiss should be noted on the dispositive motion calendar and briefed in accordance with that schedule.
And I have a question for the court, and I'm not asking the court for legal advice, but Mr. Worthington has filed discovery, including depositions. My concern, and one of the reasons that I noted this under CR 12H3, which the case law allows this court to grant the relief we have requested. We have asserted that, we've briefed that, we've cited authority for that. I understand that the court is taking a different position today. But in the meantime, if there is no subject matter jurisdiction, there is no basis for discovery. So I would request that the matter be stayed, the discovery be stayed, pending hearing on a dispositive motion, which I will know promptly.
The court is not hearing that oral motion today. And I know that that puts the parties in a difficult position. The parties will need to make decisions with regard to their actions on that, similar to other parties in other litigation before this court. But that is the ruling of the court today.
Thank you, Your Honor.
I will sign orders that are agreed to as